because someone can legally be free and still live in bondage. A nation can be free while its people are still chained by corruption. And I think as Jamaicans, we understand that a little too well. A family can be free when generations remain trapped by poverty. A person can own land but still be enslaved by bitterness within the family. Someone can have a university degree and still be imprisoned by low self-esteem. So freedom is not simply about what has been removed from you. Freedom is about what God has placed within you. And that is why tonight's lecture is so timely and so important. The topic before us speaks about land, legacy, and legal rights. Land represents opportunity. Legacy represents what we leave behind. And legal rights represent justice. These are gifts that many before us were denied. They worked the land, but could not own it. They built wealth, but could not inherit it. They contributed to society, rather, but were denied basic human rights. So the question is this: will we honor their sacrifice by wasting what they fought for or by building upon it? Every generation receives an inheritance. Some inherit money, some inherit education, some inherit pain, some inherit silence. But every generation also leaves something behind. One day, our children or our grandchildren will ask, what did your generation do with the freedom you inherited? Will they say we projected justice? Will they say we educated ourselves? Will they say we built stronger families? Will they say we strengthened our communities? Or will they say we allowed division, violence, greed, and apathy to steal what others sacrificed to give us? The Bible constantly calls God's people to remember. Throughout scripture, God says, remember. Remember where I brought you from. Remember my faithfulness. Remember my covenant. Because when people forget their history, they often repeat it. Remembering, friends, is not about living in the past. Remembering is about learning from the past so we can make wiser decisions in the future. And as Christians, we believe that every human being bears the image of God. And that truth alone destroys every lie that one race, one class, or one people is worth more than another. The gospel declares dignity after all. It declares justice and it declares freedom. So as we prepare to hear tonight's lecture, let us not simply come as spectators or just be here to make up numbers. Let us come as learners. Let us come to ask the difficult questions. Let us seek understanding. And above all, let us ask God, how can we use our freedom to bless those who come after us? Because we cannot live selfishly. Others have fought for what we are able to enjoy today, for what we are able to celebrate today. What are we going to leave for those who come after us? Because true freedom is never just about me. It is always about those who follow me. And so as we go through tonight, I urge us to remember the text from Luke 4:18 to 19, as we challenge ourselves in asking what is it that we are leaving behind, even as we reflect on what was left behind for us. I invite us to bow our heads in our different spaces as we go to God in prayer. Let us pray. Heavenly Father, we thank you because you are the God who hears the cries of the oppressed and stands with those who suffer. Thank you for the gift of freedom and for the courage of those who endured unimaginable hardship so that future generations could live with greater dignity and hope. As we observe this emancipation, O Lord, keep us from reducing the season to just celebration. Give us hearts that remember, minds that seek understanding, and lives that pursue justice. Teach us to value the freedoms we enjoy and to use them responsibly for the good of others. We pray for our nation, our island Jamaica. Heal the divisions that still exist. Give wisdom to our leaders integrity to our institutions, compassion to our communities, and courage to all who work for justice and righteousness. We pray for our presenter this evening. Fill him with clarity, O God, wisdom and confidence as he shares. May every word educate us, challenge us, and inspire us to think deeply about land, legacy, legal rights, and our responsibility to future generations. And finally, O Lord, help us to remember that the greatest freedom is found only in Jesus Christ. So may we never use our freedom selfishly, but as an opportunity to love, to serve, and to uplift others around us. May this evening be more than a lecture. May it become a catalyst for meaningful conversations, transformed hearts, and renewed commitment to building a society that reflects your justice and your love. We ask these things in the powerful name of our Lord and Savior, Jesus Christ, our liberator. Amen and amen.
Amen. Thank you, Sister Chantal. And we move on to a quick overview of the Emancipation Lecture. This is our 5th Emancipation Lecture. And the objectives we had were to increase awareness of the Moravian Church's historical involvement in slavery in Jamaica and the Cayman Islands, to critically examine the role of the Jamaican Moravian Church during the era of slavery, to recognize the Moravian Church's contributions to the emancipation of enslaved people and the development of their descendants, and fourth and final, to examine the enduring impact of emancipation on Jamaican society in the 21st century. And this year, our objective is to examine the journey from emancipation to land ownership, legacy, and legal rights. And the theme is Fee Simple, Not Simple, the journey from emancipation to land, legacy, and legal rights. And just a quick reminder of our previous lectures. The first one was the Moravian Church in Jamaica, Complicity and Subversion During Slavery, and that was done by Reverend Dr. Paul Gardner. The second one, the church and its role in the emancipation movement. The case of the Sam Sharp Rebellion was done by Reverend Dr. Devon Dick. The third one, the Moravian contribution to popular education in Jamaica, Sister Lucinda Peart. And the fourth one, Freedom Come, Understanding Land Rights and Ownership, Brother Lowell Morgan. And this evening, he's going to give us part 2 of that lecture. And I invite Sister Ruth Stevenson to give a quick introduction of Brother Lowell Morgan to us, and then I'll ask Brother Lowell to go right into his lecture.
Good evening, everyone. Mine is a task to introduce our presenter for this evening.
And I'm embarrassed about it now.
Okay.
He is a native from the parish of Manchester.
Don't you want to know why?
He seems to have adopted Kingston as his second parish. He was called to the bar in 1991, and since then has built a distinguished career spanning for more than 3 decades in law. His practice is wide-ranging and includes civil and commercial litigation, insurance, and personal injury law. He has successfully represented clients before the Supreme Court, Court of Appeal of Jamaica, and is frequently sought for his skill in handling complex disputes. In addition to his legal practice, he plays a leading role in the governance and development of profession, serving as chair of the Finance and Accounting Committee of the General Legal Council, a member of the Jamaica Bar Association's Continued Legal Education Committee, and course director of the Norman Mandel Law School. He's also active in education and community service, serving on several boards and as treasurer of the Moravian Church in Jamaica and a member of the Provincial Elders Conference. A frequent speaker at conferences and seminars, he is recognized not only for his legal expertise, but also for his dedication to mentorship, professional standards, and access to justice. So I present to you our presenter, Brother Lowell Morgan.
My brothers and sisters, friends, all good evening. I'm going to ask you to tarry with me just for a maximum hour. I'm going to try and take 20 minutes break as we seek to get through this paper. Thanks to DEMI, the Department of Education, Mission and Youth in the Moravian Church in Jamaica, for giving me the opportunity to complete part 2 of this presentation. Part 1 was done, I think, 2 years ago. Today is a special day for me. I remember my dear mother. Today would have been her 85th birthday. And I do this lecture, as always, in her memory. I think I told you last time she was my biggest cheerleader. And I'm sure if she was with us, she would be the first one to have logged on just to observe and to give me feedback. But for the grace of God, I am what I am. A sinner saved by grace. I ask for your silent prayer as I go through this paper and as I go through life generally. We can do nothing and can achieve nothing without the leading of our Lord. And so we're always eternally grateful for his grace and his favor. Fee simple, no simple. That's the task, that's the title. And I'll tell you how I ended up with that title shortly. So on August 1, 1838, 300,000 Jamaicans walked out of bondage into freedom. What they did not walk into was land. So what I'm trying to do in this paper is to trace the journey from that morning to present day. And I will want to argue that the story of Jamaica land law is in truth the story of Jamaican freedom itself. So I do this paper in 3 parts, and I say I will just take a break after each part. The first part I'll explore what land meant at the time of emancipation and why the conversation around ownership, security, and prosperity has persisted. What land meant at the time of emancipation. The second part, I describe the practical and legal steps from occupying land to obtaining full ownership. And I'll cover aspects such as registration, documentation, taxes, surveys, and the process involved in the registration of Titles Act. That's the second part, practical legal steps from occupying and owning land. Third part, I will seek to address what occurs after you obtain your title. The protection of the asset against encroachment, careless title naming, and the silent erosion caused by an absent will, as well as the role of land as a genuine engine of generational wealth. But my friends, I believe that running through that journey is a question of estate planning, which is what I primarily spoke about 2 years ago, which for most Jamaican families is not a matter of wealth, but of survival. Because I believe land is the estate. So how it is documented, how it is protected, how it is passed on, determine what it becomes, whether it becomes a foundation for the next generation or a quarrel that outlasts everyone who remembers the person who bought it. So I will tell you again, a will, the form of ownership of the land, we call it co-ownership. The prompt settling of an estate when a loved one dies are modest steps. Yet, I believe families most often postpone them. And in this paper, I treat them as the point where law, land, and legacy finally meet. My audience, I know, is diverse. My Moravian friends and brothers, students, I believe, church leaders, and I believe friends, and maybe lawyers. I present in the spirit of emancipation, but I do not present as a lament for past grievances, but I want to give a practical guide for securing, protecting, and passing on what can still be achieved. So not a lament, it's a guide for securing, it's a guide for protecting, and for passing on. So my friends, picture this. As my friend Trevor would say, imagine. Picture the morning of August 1, 1838. In churches, cane fields across Jamaica, from Falmouth to Spanish Town, from Sligoville to Morant Bay, people who had been the legal property of others would have woken up as individuals in the eyes of the law. The abolition of slavery in 1838 came into effect in 1834, but the historians will tell us that freedom was granted in the form of an installment plan. What followed was 4 years of apprenticeship, under which the former slaves were obliged to continue working, largely uncompensated, for former owners. It was so unpopular and so plainly indefensible that it collapsed 2 years early, on August 1, 1838. True and complete freedom finally came. There is an important detail in that history that every Jamaican should carry with them, because it explains a great deal about the land disputes that fill our courts today. When the British Parliament abolished slavery, it paid compensation of £20 million sterling. Every penny went to the slave holders, every cent. Not a penny went to the enslaves. The people who had cleared the land, cut the cane, built the great houses, and buried their dead in the soil received their freedom and nothing else. They were free, the people were free, but they were also landless. At various points, I'll pause to say something, to highlight something. And my first, did you know? Did you know, my friends, brothers and sisters, that the £20 million paid to British slave owners in 1834 represented roughly 40% of the entire annual budget of the British government at that time? The loan taken out to finance it was so large that the British Treasury did not finish repaying it until 2015. From 1834 to 2015. Not 1 shilling of that money was paid to the formerly enslaved person in Jamaica or anywhere else in the empire. So those of you who are note takers, first thing to note, 20 million pounds, 1834 to 2015, 40% of the annual budget of the British government at the time, and not a cent went to the slaves, enslaved persons. So the question is, why land became the measure of freedom? The answer is that in 1839-8, land was all of these things at once. Land was food, because a family with provision, a grown provision, could eat without asking the estate for permission. Land was independence, because a man with his own ground could refuse the wage the planter offered and not starve for saying no. The planters understood this perfectly, which is why so many refused to sell land to free people at any price. But my friends, land was also the vote, because the franchise was tied to a property qualification. So no land meant no ballot and no voice in the assembly that made the laws governing your life. It was dignity, a place that was yours where nobody could tell you to move and where you could bury your mother in peace. Land was prosperity, because a wage is spent, but land endures. To be handed to a child, and that child's child, long after everyone who remembered that slavery had gone. That is why the free people of Jamaica made remarkable strides in land ownership that astonished contemporary observers. Within 3 years of gaining full freedom, the freed people in the parish of St. Anne alone had spent some £10,000 purchasing land, an extraordinary sum for a population that had owned nothing whatsoever 3 years earlier. They pooled resources. They bought through the church when the planters would not sell to them directly. They cleared hillsides that nobody else wanted, and they built out of nothing the Jamaican peasantry. I said the title of this paper is Free Simple, No Simple. Fee simple is the legal term for the most complete form of land ownership available. Fee simple, a simple legal term for the most complete form of land ownership available. If you strip away all the medieval language, it means this: you just own the land outright. You own the land outright for an unlimited time, and you can sell it, you can mortgage it, you can give it away, you can leave it in your will to whomever you please. It is ownership without an expiry date. Fee simple. So when a Jamaican says the land is mine, fee simple is what they mean. Remember? You own it outright for an unlimited time. You can sell it, you can mortgage it, you can give it away, you can leave it in the will for whoever you please. The ownership doesn't expire. The land is mine. It means whether they know the term or not. When the Jamaica say, the land is mine, fee simple is what he means. And he or she doesn't necessarily have to know the term. The term simple in fee simple does not mean easy. It doesn't mean a simpleton. It is an old lawyer's word meaning unrestricted or without limitation. But the accidental double meaning is too good to waste because it points at the central truth of this paper. The law refers it fee simple. Real life calls it something else entirely. You may have lived on a piece of land, my friends, your whole life and have no legal claim to it. You may live on a piece of land for your own whole life and you have no legal claim to it. You may hold what we call a certificate of title and still lose the land to a person who had been quietly occupying a corner of it for 12 years. You may inherit land from your father and be unable to sell it or mortgage it or even fix the roof on the house on it because it is registered in the name of your great-grandmother who died before independence and nobody ever went to court. But you may also put your son and your daughter's name on your title as kindness and discover that you have accidentally inherited your other 3 children or your other children. Meaning, I'm suggesting you could put your daughter's name on it, but you have 3 sons and you end up disinheriting in it. In other words, fee simple, my friends, not simple at all. So key takeaway that you could note, fee simple is the fullest form of ownership our law recognizes. Yours outright, forever, to sell, to mortgage, or to leave by will. But holding land and legally owning it are 2 very different things. Much of this paper is concerned with the gap between the 2 and how to close it. But why this matters in 2026? I'm suggesting firstly because the problem was never fixed. It was never fixed. Jamaica has, by every serious estimate, a very substantial quantity of land occupied by people who would have no registered title to it. Some of it is family land held informally across 4 and 5 generations. Some of it is captured land. Some of it is land that was properly bought decades ago, but where the paperwork was never completed. Every one of those parcels is a family's wealth, sitting in a form that cannot be borrowed against, cannot be safely sold, and cannot be cleanly inherited. So that's the first reason why I think in 2026 it is still important. But the second thing I'm saying, because untitled land is poor land. My friends, this is not a moral judgment, but it is an economic fact. If you don't have a title, it is poor land. A registered title is the key that unlocks the formal economy. With it, you can get a mortgage, you can get a business loan, you can access agricultural credit, you can insure the property properly, you can sell at full market value. Without it, the land may feed you. I'm talking about the registered title. Without it, the land may feed you, but it will not finance you. A family can sit on an asset worth millions of dollars and be unable to raise $5,000 against it because there's no registered title. But the third thing, because the clock is always running, Jamaica land law contains a doctrine which I'm going to speak about in part 3. I'll examine it, under which a person who occupies land openly without your permission for 12 years may acquire the legal right to it, and you may lose it. It does not matter that you hold the certificate of title. It does not matter that you are paying taxes. So if you're in Miami or in New York or Pennsylvania and somebody is in Manchester farming your land, or St. Elizabeth, your 5 acres, my friends, time is not on your side. Most of the land disasters that comes across Jamaican attorney's desk were entirely preventable 10, 20, or 30 years earlier by a document that would have cost a fraction of the court battle that followed. Time is not on your side. So what's the roadmap to estate planning? The common theme that connects the 3 parts in estate planning. That term sounds like something reserved for wealthy or for the wealthy people in Jamaica. But in Jamaica, it means something far more ordinary and urgent, because for most families, the land is the estate. So don't get confused, don't get concerned when you hear people talk about estate planning. Don't believe that it is for the rich people. It is for the ordinary folks, it's for everybody. Because that estate planning that we're talking about is the land. It is the one substantial asset acquired across a lifetime of work. The land and a will that I always encourage us all to make. The right form of co-ownership, which I'll talk about a little bit more, whether tenant in common or joint tenancy, and the prompt settling of an estate on the death of our loved ones are modest steps, most often postponed. But in this paper, I treat them as the point where law, land, and legacy finally meet. Part 1. So to understand Jamaican land law, you must first understand Jamaican land. Not the law of it, but the fact of it. So by the early 19th century, this island had been organized almost entirely around Sugar Estate, and a relatively small number of proprietors, many of them living comfortably in England and represented locally by lawyers and overseas, held vast acreages of the best and flattest land. The enslaved population lived on those estates without any legal interest in the soil whatsoever. What they did have by custom rather than by law was provision ground, which is a plot, usually on a marginal or hilly land. The estate could not profitably plant, where enslaved people were permitted to grow food for themselves and to sell the surplus at Sunday markets. The planters understood the maths as clearly as the freed people did. A laborer withholds his own ground could not be compelled to accept low wages. A laborer with nowhere to live could be charged rent for the hut he already occupied and evicted from it the moment he refused work. So accordingly, many estates adopted a straightforward policy. No land would be sold to the formerly enslaved people at any price. But my friends, what ultimately broke the blockade was the church. The church. Nonconformist missionaries, principally the Baptists, but joined by the Moravians, the Methodists, and the Presbyterian, they raised funds in Britain and used London agents to purchase estates and abandoned properties without revealing who the eventual occupants would be. They then subdivided those properties into small lots, sold them with title to members of their congregations at prices ordinary people could reach. So you get Sligoville in St. Catherine, founded in 1835 by the Baptist minister James Philippo, is generally recognized as the first. You have Sturge Town in St. Anne, followed in 1839, named for the Quakers abolitionist Joseph Sturge, who lent the Reverend John Clark £400 to buy land. Buxton and Clarkstonville in St. Anne, where the names carried the names of British abolitionists. Betheltown in Westmoreland. Maidstone, that's where Nazareth is. And Beeston Springs, Salem, under the Moravian direction. Kitson in St. Catherine, and dozens of others follows. But friends, in Trelawney, on a piece of ground chosen after 1838, the settlers gave their village a name that says everything about what they had been through and what they expected of the future. They called it time and patience. Time and patience. Got some yam today from time and patience. So did you know that each free village was typically built around a chapel and a school? The missionaries did not merely sell the land, they built the institutional life of rural Jamaica in the process. The Free Village movement was in effect the first mass land titling project in Jamaica. Crucially, the lots were sold with title because the founders understood correctly that possession without paper was no security at all. I want to say something about family land. Family land, my friends, is a uniquely Caribbean creation. It is not a category recognized by any Jamaican law. You will not find a Family Land Act in Jamaica. And yet, every Jamaican knows exactly what it means. And the courts of this island have spent a great deal of time working out what to do about it. In its classic form, family land arises like this. An ancestor acquires land. On death, whether by will or by custom, the land is left to the family or to all my children without subdivision. From that point forward, the land is treated by family as belonging to the whole line rather than to any individual. Any descendant has the right to live on it, to build on it, to farm it, and importantly, to be buried on it. Nobody has the right to sell it. The land is understood to be held in trust for generations not yet born. But here is where custom and law part company. The law of Jamaica has no concept, I said, of land owned by family as an entity. Land must be owned by an identifiable legal person. What the law actually sees when it looks at classic family land is usually one of two things. Where the original owner died leaving a will dividing the land among the children, or the person died without a will and the land passing to several heirs, the descendants typically hold as what we call joint tenants in common. Nobody owns a particular corner. Everybody owns a fraction of everything. On the death of a tenant in common, the shares passes to the estate and goes to their own heirs, which is precisely how one ancestor's 5 acres becomes 23 people fractional interest within a century. Where the land was transferred was never legally completed at all. The position is worse. The registered proprietor remains the long dead ancestor. The living occupants have no registered interest whatsoever. They may have the right in equity, we say, and they may have rights arising from long possession, but on the face of the register, they are strangers to the land they were born on. So I pointed a common mistake. We don't need to do anything. That's what people think. Everybody in the district knows it is our family land. Mistake. Don't say we don't need to do anything because everybody in the community knows it is our family land. District knowledge is not a legal interest. It will not satisfy the National Land Agency. It will not satisfy a bank. It will not stop a determined relative, and it will not stop a stranger with a lawyer. The moment the land needs to be sold, mortgaged, subdivided, or developed, the absence of paper stops everything cold. What the courts have said. Justices of Appeal, Mrs. MacDonald Bishop, in a case Fulford and Churchyard, is the local authority. It is about a case where land is, well, what she did in the case is outline the various principles, but I think that I will skip it. And also there's another case, Wheels and Wheels, I think, which deals further with it. But I go to key takeaways from the cases and the principle. If you have an interest in family land and you live abroad or simply live elsewhere on the island, doing nothing is not neutral. It is a decision with legal consequences. If you have an interest in family land, or if you live abroad, or simply live elsewhere than where the land is on the island, you can't just do nothing. If you do nothing, it is a decision with legal consequences. So what you must do? You must visit the family land. You must contribute to the taxes and keep the receipts in your own name. You must write to your relatives acknowledging your interest and keep copies. you must make sure your presence on that land is documented and not merely remembered. But I must hasten to say, it would be wrong to present family land purely as a problem. It has its advantages. There are real advantages. Because it has kept land in Jamaican hands. It has prevented the distressed sales that would have followed every family financial crisis over the past centuries. It has given shelter to people who would otherwise have nowhere. And it has preserved burial grounds and physical connection to ancestry that money cannot replace. And it has embodied a genuinely admirable ethic that belongs as much to the unborn as to the living. So my friends, I don't want you to leave with the thought that I'm saying family land is a bad thing. There are advantages. Another key takeaway, succession planning is not something for wealthy people. In Jamaica, it is chiefly something for land-owning families of ordinary means, because for those families, the land is the estate. 3 documents prevent the overwhelming majority of family land disputes. 3 documents can prevent that: a valid will, a completed transmission or transfer after each death, and a certificate of title that names living people. One generation plants the breadfruit tree so that another can eat. But in the ground, the tree stands on is not proper. But in the ground, the tree stands on is not properly titled. The next generation may find that they cannot pick the fruit. I want to mention briefly categories of land tenure in Jamaica. Jamaican land is held under several distinct tenures, each carrying its own rights and risks. You can have freehold land. You can have crown land. We talk about common or joint ownership, and I mention family land. I leave you with these key points from part 1. So freedom came in 1838 without land. And the free people of Jamaica spent the following century acquiring it against determined resistance. The free villages built by the churches and paid for by the free people themselves were the first mass land titling exercise in our history. First mass land titling exercise in our history. And their founders understood that title mattered. Family land preserved that inheritance socially while eroding it legally, because custom was allowed to substitute for documentation. Land in Jamaica is an intergenerational asset. It performs that function only if each generation completes the paperwork the previous generation postponed. Those were the 4 or 5 takeaways that I want you to have in relation to part 1 of this paper. I on to part 2, and I'll just take a 1-minute break, have a sip of water, and then continue. Part 2 deals with the path to ownership. Having the land and owning the land are not the same thing. Having the land and owning the land are not the same thing. There is a sentence that every Jamaican lawyer hears several times a week. We hear it, usually delivered with complete confidence and often with a certain indignation. What you mean the land is not mine? I lived there for 40 years. I pay the taxes. Everybody know is my land. What you mean the land is not mine? I lived there for 40 years. Me pay the taxes. Everybody in the community knows that it is my land. My friends, the honest answer is that living somewhere for 40 years, paying the taxes on it, and being universally, everybody in the community know that you are supposed to be the owner, they are all extremely helpful facts. They are not by themselves ownership. They are evidence that may support a claim for ownership. But the claim must still be made, this claim must be proved, and the claim must be registered. So let's talk about a couple of things. Occupation. Me occupy it. Occupation is simply being physically present on the land. But a tenant occupies. A caretaker occupies. A squatter occupies. So my friends, occupation by itself says nothing about your rights. Possession is stronger. In law, possession means that you have sufficient degree of physical control over the land, coupled with an intention to possess it as one's own, as your own, to the exclusion of others, including the person who is the paper owner. So fencing it, cultivating, building, controlling access, excluding others are classic indication of possession. Possession of the right quality, maintained for long enough, can generate legal rights. Ownership is the legal title itself, the right recognized and recorded by the country, the state. In Jamaica, for registered land, ownership is evidenced by what we call a certificate of title issued under the Registration of Titles Act and recorded in the Register Book of Titles. So common mistake. I pay the property tax, so the land is mine. Mistake. This is probably the single most widespread land myth in Jamaica. So many people. I pay the tax. The land is mine. My friends, my brothers and sisters, paying property tax does not make you the owner. It is useful evidence of a claim to possession, and it is a good habit for many reasons. But the tax roll is not the register of title, and our courts have expressly noted that your name on the tax roll may in fact be the name of the person who owned it before, who has now been dispossessed. So I say, yes, pay your tax. Absolutely. But do not mistake a tax receipt for a certificate of title. Do not mistake a tax receipt for a certificate of title. We have registered and we have unregistered land. So Jamaica has this two parallel system, and every transaction starts by identifying which one applies. Most land is registered on what we call the Torrance-Based Registration of Titles Act, where the state's register is conclusive. The certificate of title is ownership itself, and a purchaser need not look behind it, thanks to what we call indefeasibility of title. A shrinking amount of land remains unregistered, governed by the old deed system at the Island Record Office. Here, ownership rests on an unbroken chain of deeds rather than a single conclusive document. There are some institutions in Jamaica that you should be aware of and what they do. Who does what? The National Land Agency is the executive agency responsible for land titling, for surveys and mapping, land valuation, estate management, and it houses the Office of Titles, where the Registrar of Titles operates the Register Book of Titles, and it is where applications for registration, transmission, splintered titles, lost titles, and possessory titles are processed. The Registrar of Titles is a statutory officer under the Registration of Titles Act with responsibility for the register who issues, and she issues, or he issues the title. You will hear about the term a commissioned land surveyor. That person is a professional licensed under the Land Surveyors Act to survey land and prepare survey plans on which titles boundaries depend. Only a commissioned land surveyor can produce a plan that the Office of Titles will accept. You hear about an attorney at law. That person conducts searches, prepares and settles what we call instruments of transfer or mortgage, attends to stamping and registration, and advises on the legal consequence of the structures chosen. In Jamaica, conveyancing is legal work and it is regulated as such. You have an office called the Tax Administration of Jamaica. It collects property tax, stamp duty, transfer tax, issues receipts and certificates without which a transfer can't be executed. And you all know about the Supreme Court of Jamaica that grants probate, letters of administration, etc. You would hear about the certificate of title. A Jamaican certificate of title is a deceptively short document, and every landowner should be able to read one. It shows the volume and folio, which is the address of the land in the register book. This is the reference number by which the title is searched, and it is the first thing that usually an attorney will ask for. So all of you who have your titles, you should read it and understand what is on it. The volume of folio number. It gives a description of the land, identifying the parcel by reference to a registered survey plan, its area, and its location by parish. The registered proprietor being the person or persons in whom the land is vested, who owns it, and where there is more than one, the manner in which they hold, whether they are joint tenants or tenants in common. And then it will also list what we call encumbrances, endorsed on the title, including mortgages, what we call restrictive covenants, easement, caveats, and any transmission or transfer that has been registered. Look at your title. Also, it is important that you keep it safely. Put it in a scandal bag. No. If you put it in a scandal bag, if you're keeping it, you make sure it's also in a Ziploc bag. It must be safe and secure. Some people put it in the bank, vaults, etc., etc. It's an important document, and that you should try to ensure that you keep it safely. Practical tip. Read your title. Actually read it, the front and back. I want you to also check that your name is spelled correctly and matches your identification documents exactly. So if your name John Brown, make sure it says John, John Brown, Brown, because that John Brown is different from Brown, Brown. Check on your title to say whether it says joint tenants or tenant in common, because that single phrase determines what happens to your share when you die. Check the encumbrances page, because many Jamaicans have discovered old mortgages that were repaid decades ago but never formally discharged. I want to touch on lost or destroyed or damaged titles. You should know what the loss does prevent its dealing with the land, because a sale, mortgage, etc. requires the possession of the duplicate certificate of title. The remedy, if your title is damaged or lost or damaged in Hurricane Melissa or Gilbert or Beryl, is an application to the Registrar of Titles for a replacement duplicate certificate of title. If your title damaged, lost, you can get a replacement. The application is made supported by statutory declaration explaining when and how the title was lost and what searches have been made for it. So my brothers and sisters, don't be despaired, don't be disheartened. If you lost the title, if the title wet up, if the title destroyed, you can get a replacement title. You make an application, you have to do a statutory declaration, you have to explain that I had it in my drawer, Gilbert come or Melissa come, and everything wet up. The application is advertised, and if there are no objections within a prescribed period, a replacement issues, and the original, a replacement is issued, and the original is cancelled on the register. So don't be disheartened, don't be despaired. A lost title can be replaced. It's a process. I want to touch briefly again on buying land safely, step-by-step process. The following is the ordinary sequence of a registered land purchase in Jamaica. In the paper, I say step 1, and I always recommend retain a lawyer if you're buying land before you pay anything. You retain the lawyer, not after you pay the deposit, before you pay the deposit. Money paid to a stranger for land that turns out not to be theirs is, in practical terms, gone. The attorney's first task when you retain the attorney is to confirm that the person offering to sell is in fact the person entitled to sell. So step 1, retain a lawyer. Step 2, search the title at the office. A search of the register book will reveal the registered property, the current encumbrances. The lawyer will help you with that, and whether any caveats have been lodged. A caveat is a formal warning entered on the register by a person claiming an interest in the land, and it operates to freeze dealing with the land until it is resolved. I say step 3, verify the seller's identity. This is where most damaging frauds occur. The title may be perfectly genuine, and the person presenting it may simply not be the registered proprietor. The identification must be examined and verified against the title. So where the seller purports to act under a power of attorney, the power itself must be examined and its currency confirmed. I say step 4, inspect the land physically and survey it. Go and stand on the land, walk the boundaries. Note who else is on it, what structures exist, whether they are tenants, farmers, or graves, and whether fences correspond to the plan. Then instruct the commission land surveyor to identify the boundaries, etc. The step 5 usually is the agreement for sale, and step 6 speaks to the stamp duty, etc. Step 7 is registration. Common mistake. We did the sale with a lawyer, but I never went back for the title. Happens all the time. An alarming number of Jamaicans have paid for land in full and never obtained a registered title in their own name. The transaction stopped at the agreement or at the transfer instrument and was never completed at the Office of Titles. Many Jamaicans. If you paid for land and cannot produce a certificate of title with your name on it, you have an unfinished transaction, not a completed purchase. So my friends, deal with it now. Whether the vendor is alive and traceable and the documents still exist. If you paid for land and you cannot produce the certificate of title with your name on it, you have an unfinished transaction. I mentioned also in the paper when the owner dies, transmission and probate and administration. And essentially, my friends, when the registered proprietor dies, the land does not automatically vest in their children. The land don't vest in the spouse or whoever happens to be living in the house. It vests in the deceased's personal rep, who must be appointed by the court before anything really can be done with the property. So where there's a valid will, that again, the executor named in it applies for what we call a grant of probate. Where there's no will or no executor able to act, an eligible person applies for what we call letters of administration, and the estate is distributed according to what we call the Interstate Estate and Property Charges Act in Jamaica. Once the grant issues, the personal reps would have a number of things to do. but we have covered that ground already on the last occasion. So did you know that the Administrator General for Jamaica may administer estates in defined circumstances, particularly where minors are among the beneficiaries? Did you know that until a grant of probate or letters of administration issues, nobody, not the eldest child, not the person who paid the funeral expenses, not the relative living in the house, has the legal authority to deal with the land? Until a grant of probate, that's when the person dies and leave the will, or if they don't leave a will until letters of administration is obtained, nobody, not the eldest child, not the person who paid for the funeral, not the relative living in the house, has the legal authority to deal with the deceased's land. I did a little Jamaican example, and if you have time, well, perhaps just listen and perhaps you will have the answers. For example, Miss Ivy's dilemma, I call it. Miss Ivy bought 3 acres of land in St. Mary in 1968, and she obtained a registered title in her name alone. 1968, Miss Ivy bought this land in her name alone. Miss Ivy has had 5 children, and she died in 1994 without leaving a will. So you get the facts. 3 acres, St. Mary, 1968. She died 1994 without leaving a will. Remember, she has 5 children. 2 of her children migrated. One went to England, one went to New York. One child died in 2011, leaving 4 children of his own. 2 remained in Jamaica. The daughter who remained, Marcia, had lived in the house since her mother's death. She maintained it. She paid the taxes for 30 years and buried 2 relatives on the land. Her nephew Damien, born in 1990, built a 2-bedroom board house at the back of the property in 2016 with everybody's informal blessing. In 2026, a developer offers 80 million for the 3 acres. Marcia, remember who Marcia was? She was the daughter who remained and lived on the land. She wants to sell. The brother in England agrees. Say, yeah man, make us sell it. But the sister in New York refused. The children of the deceased brother cannot agree among themselves. Damien says he is not moving. The title is still in the name of Miss Ivy, who died 32 years ago. What actually happened in law? Miss Ivy would have died intestate. Her land did not pass directly to her children automatically. It fell into her estate to be distributed under the Intestate Estate and Property Charges Act. Because no grant of letter of administration was ever taken earth, her estate has remained unadministered for 32 years. The registered proprietor of the land is on the face of the register a dead person, Miss Ivy. The 5 children will be entitled on intestacy to the residuary estate in equal shares in tenants in common. Understand that? So Miss Ivy, 5 children, all will be entitled to the property. When one of them died in 2011, his 1/5 did not go to his siblings. It fell into his estate, which also appears to never have been administered. So that deceased person, His 4 children now stands behind the second unadministered estate. So before anybody can sell a square foot of this land, for which 80 million is offered, 2 grants of letters of administration are required. One in Miss Ivy's estate and one in her dead son's estate. That is, my friends, 2 Supreme Court applications requiring consents or renunciation from beneficiaries in 3 countries, some of whom are not on speaking terms. What about Marcia, who stayed and maintained the land? Marcia, 30 years of occupation, maintenance and tax payment is significant. But as a co-owner, she was always entitled to possess the whole. So her occupation is not automatically adverse to her siblings. It becomes adverse only where it is exclusive and inconsistent with their rights for the requisite period. This was the inquiry that the Privy Council did in the Wills and Wills case that I mentioned. What should have happened? Instead, 32 years of silence has produced a situation in which an $80 million asset is frozen. A family is at war, and the legal cost of untangling it will consume a meaningful percentage of the 80 million that has been offered. This is the key takeaway. What does this mean for ordinary Jamaicans? My friends, when a landowner dies, the clock starts. Apply for the grant, whether it is a probate or letters of administration. Complete the transmission. Get living names on the title. Every year of delay adds beneficiaries. It adds unadministered estates. It adds costs and multiplies the number of people whose signature you will eventually need. I repeat, when the landowner passes, the clock starts. As soon as possible thereafter, apply for the probate or the letters of administration. Complete the transmission and get living person's name on that title. Every year of delay adds beneficiaries. It adds unadministered estate. It adds costs. And it multiplies the number of people whose signatures you will eventually need. Turning long possession into title, possessory applications. For many Jamaicans occupying land without documents, the question is whether long occupation can be converted into a registered title. The answer is, in defined circumstances, yes. We have an act called the Limitation of Actions Act. It provides that no person shall make an entry or bring an action to recover any land except within 12 years from the date of which the right to do so first accrued. When that period expires, the paper owner is not merely prevented from suing. The act extinguishes the owner's title altogether. In respect of land held by the Crown, that's government land, the period is substantially longer. We hear it all the time. It's called adverse possession. And I just want to briefly tell you how it works. What must be proved? An applicant must demonstrate possession, that same word again. That is, actual and exclusive. A sufficient degree of physical control over the land and control that excludes others, including the paper owner. So you must be in control. You must be open. And when we say open, we mean visible and not concealed. we used to say in law early, nec vi, nec clam, nec procaro. Without force, without secrecy, without permission. Without permission, a caretaker, a tenant, or a relative allowed to stay on it in adverse possession, however long they remain. Continuous for 12 years, uninterrupted, though possession may be defined, circumstances be added to that of a predecessor, accompanied by an intention to possess, an intention to hold the land as one's own world. So what's the evidence that wins these applications? Many of them have been made. Build the file long before you need it. The applications that succeed are the ones supported by dated, independent documentary evidence. So property tax receipts in the applicant's own name, running continuously over the period. Utility bills and receipt for the premises. Photographs of fences, crops, buildings and improvements dated where possible. Receipts for building material, fencing and payment to workmen. Statutory declaration from neighbors, district constable, community leaders or local church deponing to how long the applicant has been in occupation and in what manner. And you're going to need a current survey plan by a commissioned land surveyor, that person we spoke about earlier. Evidence of exclusion of others, notices to quit, letters, police reports about trespassers. If you make the application is made to the register of titles supported by the statutory declaration and the survey plan, if the registrar is certified, notice is given. Absent successful objection, a certificate of title may issue in the applicant's name. Where the claim is contested, the matter may end up before the courts. So in summary for part 2, occupation, possession, and ownership are 3 different things. Only the last is a title, ownership. Paying property tax is good practice and useful evidence, but it is not ownership. Registered land under the Registration of Titles Act is safer, cheaper to deal with, and easier to finance than unregistered land. Bring all deeds under the Act. Never buy land without an attorney, a title search, verified identification, and a surveyor. When one person dies, obtain the grant of probate or letters of administration and complete transmission, we say promptly. Delay is what turns a simple estate into a generational dispute. Long possession can become title, but only with evidence. Keep the receipts. Keep the receipts. That, my friends, would be part 2, and I'm on to part 3. If we could just take a 1-minute break and let me get a drink of water.
This is your time to stand and stretch. Those of you who have been sitting, or go get a drink of water too. If we weren't streaming on YouTube, I would play a little music, but we're streaming, and so I'm afraid to play. Brother Lowell, you start when you're ready.
Carry with me just for another 15 minutes or so. I know it has been a long day for many. Part 3, asset protection. It's incumbent on us, I believe, to guard what we have won. Everything to this point has been about acquiring land and getting it properly documented. But this final part is about what happens next. And it rests on an uncomfortable proposition that many Jamaican landowners have learned the hard way. Getting the title is not the end of the work. It is the beginning of a different kind of work. We spoke about adverse possession. We met the 12-year rule in part 2 as a route to acquiring title. It's an avenue that many Jamaicans have used. Viewed from the other direction, it is the single greatest threat to Jamaican registered proprietor, and it deserves to be understood properly rather than feared vaguely. The principle: a certificate of title, as I said earlier, is described as indefeasible, and the Registration of Titles Act does not make the registered title paramount, does make it paramount. But the Act itself preserves the exception that we spoke about. I spoke about the Privy Council case. There's a Lazarus case that I won't even mention now. But two aspects of the decision should give every Jamaican landowner pause. First, innocent purchaser for value lost, notwithstanding that it held a registered title. I'm saying an innocent purchaser for value can lose, notwithstanding that there was a registered title. In the Lazarus case, the lawyers will read it. His rights had already accrued to 12 years of adverse possession. Any application would merely have recorded him. What does this mean for ordinary Jamaicans? Two things, and they cut in opposite direction depending on which side of the fence you are standing. If you own land, you do not physically occupy. My brothers and sisters and friends, if you own land, you are in Kingston and you own land, or you're in foreign and you own land in Jamaica, and you don't physically occupy it. If you live overseas, your certificate of title is not a force field. Somebody in undisturbed occupation for 12 years can extinguish your ownership. I repeat, if you own land and you don't physically occupy it, because you live overseas or you live a town, the land, their country, even if you have the title, somebody in undisturbed occupation of that same land can extinguish your ownership. If you have occupied land openly, without permission, for well over 12 years, you may have far stronger rights than you realize. That's the other side of it. If you occupy land for 12 years or more, openly, without permission, you may very well have rights, strong rights, far more than you realize. And my advice is to take advice. In practical terms, an absent owner, therefore, foreign or their town or country, you should inspect the land that you own. You should go and look. You should have a trusted person do so and keep dated records and photographs. You should keep the boundaries fenced. You should pay the property tax in your name and act at once if anyone goes into occupation. The minute you hear somebody's on your land, act. You can act by a written notice. You can act by allowing the person to live, but by a lease or formal license, we call it, because those things interrupt the running of time, because possession with permission is not in law adverse possession. So where a caretaker or a relative occupies, putting that arrangement in place as a license is a single step that has saved many overseas Jamaicans their land. And also too, there's the issue of a caveat. Whose name goes on the title? Joint tenancy. Joint tenants together hold the whole land. No one joint tenant owns a distinct share. The defining nature is what we call the right of survivorship. Joint tenancy, again, the right of survivorship. When one joint tenant dies, their interest pass into their estate. Does not pass into their estate. It simply accrues to the survivor. So the principle, joint tenancy. One joint tenant dies, the land goes to the next. If you have 3 persons own the land by joint tenancy, one dies, the land goes to the other 2. The attractant is simply on debt. Where a husband and a wife holds as joint tenant and one dies, the survivor becomes the sole owner without any grant of probate or administration. The title is updated on production of a death certificate. This is quick, cheap, and clean. So for example, I'm saying husband and wife own land. Now the certificate of title, one passed. They have to do no probate or letter of administration in relation to that pass of land. You need to get the certificate and note the debt. And I'm saying this is quick, it's cheap, and it's clean. The danger is that a joint tenant cannot leave their interest by will. The will is simply irrelevant to that property because survivorship, we say, overrides that. And we see it many times. Joint tenants say, I leave my interest to X person. That particular gift will fail. Survivorship applies. Common mistake. And we see this oftentimes. I put my son on the title as joint tenant so he could help me with the business. And I left the house to all 4 of my children in my will. Put my son on the title as joint tenant so he could help me with the business. And I left the house to all 4 of my children in my will. My friends, the will do nothing. On death, the son takes the entire property by survivorship. The other 3 children receive nothing from that property. However, clearly the will expressed a contrary intention. This is one of the most common and most painful mistakes in Jamaican estate planning, and it is usually made out of love and convenience. And then, of course, you have what we say is tenant in common. Tenant in common each hold a distinct undivided share, which may be equal or unequal. There's no right of survivorship. On the death of a tenant in common share passes to their estate as is dealt with in their will or in intestacy if there's no will. All right, so tenant in common, one person dies, the property don't automatically goes to the other. The property or that person's interest goes to the persons who are slated to receive it in their will. And if there's no will, then it goes on to intestacy, which are the things that we discussed the last time. Did you know A joint tenancy can be brought to an end during the owner's lifetime by what we call severance, which converts it into a tenancy in common. Severance may occur by agreement, by one owner's dealing with their interests, or by conduct inconsistent with the continuation of a joint tenancy. That's a little fact that people can own a property as joint tenants and they can sever it. In other words, if they don't want the principle of survivorship to apply, they can sever it. And it's no longer joint tenancy, it can be tenant in common. Adding a child to your title, this deserves separate treatment because so many Jamaicans do it, usually for good reasons and usually without advice. The impulse is understandable. An elderly parent wants to make things easy for a trusted child. They want to avoid probate and they want to ensure somebody can deal with the property if illness comes, so the child name goes on the title. The consequences are frequently unintended. What are the consequences? It is a disposition. You have given away a legal interest in your property. It may attract transfer tax and stamp duty. Put in the child's name, I'm saying, it's a disposition. Second thing, you cannot simply undo it. You can't remove a name just like that. Removing a name requires the consent of the person. So if you put the child's name on the title, you can't just get up and say, may I move off the name of the title. It's not as simple as that. If the relationship sours, or if you change your mind, you may be unable to sell your own home. And I've seen circumstances, parent put child's name, and then the child now says, I want my interest. I want to sell the property to get rid of the parent. Their problems become your property's problem. If that child is sued, divorced, or becomes bankrupt, their interest in your land is exposed. If joint tenants, the other children could be disinherited as to that property, whatever the will says. There is almost always a better tool. A properly drafted will achieves intended distribution without giving away control during your lifetime. A power of attorney, for example, lets a trusted child deal with your affairs if you become unable to, without transferring ownership to the child. And a trust can hold the property for several children under clear rules. If a name is to be added at all, decide deliberately between joint tenancy and tenancy in common and record the reasons why. I touched briefly on encroachment, boundaries, neighbors dispute. Boundary disputes generate more litigation per square foot than any other kind of land dispute in Jamaica, and they are almost always avoidable. Encroachment, you know what's an encroachment? When a structure or occupation extends over a boundary onto a neighbor's land. The classic Jamaican versions are the wall built 18 inches over the line, the eaves of the roof hanging, etc. The critical point is that an encroachment left unchanneled, unchallenged, does not stay a mere nuisance. If the encroaching occupation is open without permission, exclusive and continuous for 12 years, it can mature into possessory title. So the practical tip, the single most effective step against encroachment is a boundary survey by this chappie, the commissioned land surveyor, carried out before a dispute arises, with the surveyor's marks physically placed on the ground. If you discover an encroachment, act immediately and in writing. A letter recording that occupation is objected to, or alternatively that it is permitted only by revocable license, protects your position. Permission defeats adverse possession. So my friends, brothers and sisters, do not rely on a friendly conversation over the fence. Time does not care how friendly the conversation was. It cares what you can prove. An easement or right of way is a right enjoyed over someone else's land, most commonly a right of way, but also rights of drainage, water, and support. Easement may be created expressly, and where they are registered, they appear as an encumbrance on the title. So informal rights of way are extremely common in rural Jamaica, where a track across a neighbor's land may provide the only access to a property for generations. Where such a right is not documented, its legal status can become acutely contested when land changes ownership or when a new fence goes up. The common mistake: we have always driven across my boss Joe's land to reach our property. Nobody ever objected. My friends, long use without documentation is precarious. When Mass Joe's land is sold to a developer these days, the new owner may simply block the track, and the family may find their land is legally landlocked. If access to your property depends on crossing somebody else's land, have the right of way formally granted and registered on both titles. Do it while you have good relations with your neighbor. Mention trespass and illegal occupation, where persons enter land without any right. The owner's remedy is a claim in trespass, and where appropriate, proceedings for recovery of possession. Wills, probates, etc. I touched basically on that. But a practical tip: a functioning family land plan usually has 4 elements. A valid, professionally drafted will for each land-owning adult, prompt application for probate or letters of administration on each debt, a clear decision on co-ownership form recorded on the title. So you think about it seriously whether it should be joint tenants or tenant in common. A written family agreement where land is held collectively, setting out who may occupy, who bears the taxes and maintenance, and what happens if somebody wants out. I spoke about valuation, borrowing, and turning land into wealth. Usually we have this person, as I say, called evaluator. I mentioned mortgages. You can get a mortgage on your land. But a common mistake I think you should be aware of this: the bank will not lend us because the title is still in grandpa's name. So if the land is in grandpa's name, the bank is not lending your money. This is not the bank being difficult. No responsible lender can take security over land from a person who is not the registered proprietor. The land may be worth millions and still be useless as a security. So it's important that you regularize the title, ensure that the paperwork is completed, and you can convert the family's largest asset into usable capital. I must say, though, in all of this, that if you are borrowing, you must borrow responsibly. Borrowing against land carries a real risk, and it should be stated plainly. If the loan is not repaid, the family can lose land that took 4 generations to acquire. That is not theoretical outcome. It happens in this island regularly. Before mortgaging family land, borrow for something that produces income or lasting value rather than consumption. Understand the interest rate and the true monthly costs if rates move. Read the power of sale provisions so you know how quickly a lender can act on default. Where the land is co-owned, every co-owner should understand and consent in writing. Mortgage protection insurance should be considered so that a debt does not become a foreclosure. And independent legal advice should always be taken out. So in summary for part 3, my friends, a certificate of title is not self-executing protection. Land can be lost after it is properly titled. So even if you have your title, I'm saying you can lose it. 12 years of undisturbed adverse possession, occupation, can defeat a registered title, and the innocent person suffer value, as in the Lazarus case. The words joint tenants or tenant in common on your title determines what happens to your share on death, and no one can overrule survivorship. And people always ask me which is better, and my answer is always what it is that you want to happen to your property when you die. You determine that. That's the important question. What should happen to my property when I die? What I want to happen. And you decide whether you should own tenant in common or joint tenancy. Encroachments and undocumented rights of way should be dealt with in writing early while relations are good. A will, a prompt grant, and a completed transmission prevents most family land disputes before they begin. A registered title turns into land into capital. That is the difference between owning an asset and being able to use an asset. So my friends, I'm almost there. Finishing what 1838 began. Let us return to that morning in August. 300,000 people walked out of slavery with their freedom and nothing else. They had no land, no compensation, no capital, and in most cases, no expectation that anyone would help them. But within 3 years, they were buying land in their thousands. Within a generation, they had built the Jamaican peasantry. They had founded villages. They had raised churches and schools and established on this island a class of independent proprietors that the planters had sworn would never exist. The estate that has sat unadministered can be administered. The old deeds can be brought under the Registration of Title Acts. 40 years of possession can be documented and turned into a possessory title. The joint tenancy that will accidentally disinherit 3 children can be severed. The right of way used since independence can be formally granted and registered. The will that has never been made can be made now. What none of it survives is postponement. Every one of these problems is cheaper today than it will be in 10 years, and every one of them is dramatically cheaper today than it will be after the next death in the family. The generation of 1838 bought land, and they knew they would not enjoy for very long. There were many of them, elderly by the standards of the time, and worn out by what had been done to them. They brought it anyway, and they built on it, and they held it because they understood something about land that we sometimes forget in the middle of a title search, that it is the instrument by which one generation speaks to the next. One generation plants the breadfruit tree so another can eat. That is the whole of it. But the tree has to stand on ground that the family can prove is theirs, or the next generation will inherit the quarrel instead of the fruit. So my friends, get the title, read it, make the will, complete the transmission, survey the boundary, keep the receipts, tell your children where the documents are. Fee simple, no simple, but it is not beyond us. It was never. I thank you. I know I have gone maybe 15 minutes too long, but thank you for your time and your attention.
Thank you, Brother Lowell. Not too long at all, not too long. I think all of us were just sitting here taking in what you were saying, and nobody was bored, I'm sure. There are some questions that are in the chat, but if anybody has a question, feel free to raise your hand. Let me see if I can go back and find those that were there in the chat from the beginning. Okay. Okay, so in essence, can one sell their land to bauxite companies?
Yeah, man. Why not? But I'm not sure, is that exactly what the person wants to ask? If they can sell their land to the bauxite company?
Near the rivers or
Yeah,
not?
but I must also tell you too that what especially because I see it especially in Manchester here and St. Elizabeth, where the government compulsory acquires land for bauxite purposes, and that is permissible, and I think the case law says the responsibility of the government, some long time case say you must be paid adequate compensation. So if bauxite is on your land and the government wants the land for mining purposes, etc., the government will acquire it, compulsory acquisition of the land, but you must be paid for it. And I know in cases down by Jamaica and other places, they even count the fruit trees, they count the number of orange trees, and they have some kind of standard by which they value it. So not only the land, but the trees. And I also know that sometimes it's very heartbreaking for many persons because some of the land would have their loved ones on it. And I know of cases where they remove the bodies, the graves, and put them elsewhere. And sometimes they don't do it so cleanly because they don't let the family members know. But I'm saying, yes, the government can compulsory acquire the land, but they are required to compensate you. I hope I answered. Okay.
Brother God, you have your hand raised. You want to go now?
Thank you, Sister Upnakiwing. I want to thank Brother Lowell for an excellent presentation. I'd just like to find out, we as a church, meaning the Moravian Church, we are landowners in just about all areas from across the western part to the eastern Surrey part. And what I do know is that a number of these areas, it is said that our lands have been possessed by other persons who have encroached and have done legal work in terms of acquisition. What I do know too is that lands which have been acquired through fraudulent means can be overturned in terms of the titles. With that sort of knowledge, what can we as a church do with respect to regaining those lands that have been taken from us as a church?
Well, I got you touch on something, and everybody know the latest case. Many persons talk about it. Yes, it is a fact that we had 469 acres, I believe, at the incorporation of the church in 1884. And if you go there now, we have very little left. In recent times, the government has compulsory acquired a portion. We have very little left, and most of those persons in the area would have obtained their certificate of titles, because the very thing I'm talking to you about, adverse possession, and they have their title. And remember, I told you about the indivisibility of title. So in a lot of those cases, there's very little that we can do to get back some of those lands. What you should know is, though, as a church, we do have a listing of all the lands that we own. Those with registered title, those without registered title. And you should know that years ago we would have collected information from all our pastors and church leaders about lands on, where the church is located and stuff. So we have a good record of it. But a lot of it is not secure, a lot of it is not fenced, and some of it persons are squatting on and will eventually obtain title. We have a responsibility to ensure that it doesn't happen. Remember, I was saying you should watch the land, see what is happening, walk the land. And as church leaders, the various congregations, once you know the church owns a piece of land, you have a responsibility in terms of how you treat with it. And don't let any other portion of our land we lose through adverse possession.
Yeah, I think we need to be more proactive with that's concerned. But in my case, Brother Lowell, I personally had a situation in which I had a case in the Supreme Court from 2010, and we never got through with that case until 2018. That's 8 long years in which piece of my property, more than 2.5 acres, was acquired, a title was acquired by the person through fraudulent means. And because the lawyer was able to prove in court that it was acquired through fraudulent means, that title was declared null and void, and I got back my land. So I'm
Good.
wondering if something like that cannot be done with the Moravian Church, where
But
those
remember,
persons acquire the
but
land.
remember, Brother God, you said by fraudulent means. So, and clearly you had legal advice. And remember, throughout this paper, I said many times, seek legal advice. But you said by fraudulent means. But adverse possession doesn't mean fraudulent means. You understand?
That's another side to it.
Right. Adverse possession don't mean fraudulent means.
No, thanks for the bit of advice, Brother.
Thank you, Brother Gant. Next
You're
question in
welcome,
the
Brother
chat.
Sister.
Can a U.S. attorney legally help to establish a will and trust? What if you have a trust, but the land is not included, only have property tax receipts, but no title?
Well, remember, I keep saying, I spoke about it. Tax, the tax, paying the property taxes and having the tax in your name is not sufficient. It's not the be all and end all of it. You need now to go to the next step. Get your certificate of title, get your survey diagram, and do the necessaries to get a title.
Okay, so this is
And I think, I'm not sure what the person is asking. Usually, I'm not a trust lawyer, but I know, for example, that usually the person says something about US. Yeah, and I think the advice always, I think, is to, if you have property in Jamaica and you have property in the United States or in Canada, that you make a will up there to deal with that, and you make a will in Jamaica to deal with your Jamaican property.
Okay. This person, Patrick Brooks, says, well structured and informative. Congratulations. And his question is, how much of Jamaican land is still unregistered? I don't know if you can answer that one.
Judge, I don't know, but I think it is a significant portion. I think it is a significant portion, Justice Brooks. Thanks for your kind words. I really don't know.
Okay, excellent presentation, Brother Morgan. Excellent presentation, Mr. Morgan. Thank you, and plenty clap. Excellent presentation, very informative.
Those are not questions. Those are not questions. Those are not questions, Sister Veronica.
All right, good.
It's after 8:30. Remember, we have church tomorrow.
Yes, going down.
Thank you for your kind
All right,
words.
that's it.
See you all next year.
All excellent. Oh, so you're coming back next year? More information? Yes.
Veronica, there's another one on the chat.
Okay, which is it? Can you help me, please? Oh, this last one here, Sister Lucinda. Okay, I see it, sis. Moravian church lands. Is there an active effort to prevent more lands from being possessed? In other words, is there a lawyer or the legal aid assigned to seriously retain our Moravian land?
I am not sure if there's an active step, but this could be part of the exercise in terms of what we do, all of us here, and in all our congregations out there. For the lands that we own, whether at Bethabara, at Nazareth, at Bethany, Beaufort, Springfield, wherever, the lands that we own, we have a responsibility, our steward boards, our ministers in the local area, to ensure that we safeguard our lands. Ensure that we safeguard our lands. The minute you see somebody encroaching, deal with it. But I hear the question is suggesting also that we need to be more deliberate about it and put in some serious plans to deal with protecting our lands so that other persons don't get this the benefit of it. The land is the estate.
Okay. Danisha Nichols, you were asking how you can access this presentation. If you send me a direct question here, if you send the question to me directly, I can. No, that's not it.
But
Send
you have
your
you have the
email
script.
to me directly and you can get it. Yes, I'll send it to you. So give me your email or WhatsApp number and you can get it. And that's for everybody. Okay, so thank you so much, Mother Lowell, for this very informative presentation. I know everybody online has learned a lot this evening. And I hear you saying there's still more for us to learn. So come back next year for more.
Oh boy, there's always something.
All right. Okay.
Anytime for church. Thank you.
Okay. Thank you,
All right.
Sister Chantal, for devotion, Sister Ruth for introducing Brother Lowell, and for all of you who are on, who came on and are still here.
All right, the people not going to their beds.
Thank you for staying. And just a little notice, convention coming up. We have a week or 5 days of pre-services, August 16 to 20. It will be online, so listen out for the link and join us those evenings, all of you that are online now. And the convention, Reverend Adrian Smith will be preaching. Join us again. It will be on YouTube, same channel. So feel free to join us. And we are going to end with the national anthem.
Just before you go, Sister, I believe
Yes.
Brother Lowell can make some money out of this by putting the presentation in book form.
I hear you, Brother God.
Something to
Okay.
consider, sir. Something
All
to
right.
consider.
Thanks.
You're welcome.
Okay, so the national anthem. Let me make sure I'm still sharing sound. Yeah.
You, just you, building your app
Ah,
on base 44. Describe it. And it's
Eternal Father, bless our land. Guide us with thy mighty hand. Keep us free from evil powers. Be our light through countless hours. Jamaica, 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 land we love. Teach us to respect all, stir response to this call, strengthen us to give us wisdom, let reflect knowledge, sentence, heavenly Father, grant wisdom from above. Justice, truth be ours forever. Jamaica, land we love. Jamaica, 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 land we love.
Amen.
Thank you all for coming out. See you again next year. Same time, same place. Okay. And for the sports loving people, I understand that our 4x4 girls got a gold, and our netball team, that's my sport, we beat Australia and we are in the finals.
We
Don't
beat
know what
Australia.
else is going on. Yes, we beat Australia.
Excellent, excellent.
Yes.
Some more
All right,
boost
so
up your confidence.
yes. Good Emancipation Day present. So, bye, everybody.